Well, my topic's called the news round. No, it's not called the good news round, because the first item I'm going to tell you about I don't think is good news for most employers. Employment tribunal claims have increased by 165%. This is because, you'll remember a few years ago, before a claim could be brought in the employment tribunal, an individual had to pay a fee. Now, those fees were abolished in July 2017, and since then claims have gone through the roof. As a result of that, the backlog, the delay at the tribunal, has become substantial. So if you're in the unfortunate position of being an employer, the chance of you getting a claim has increased more than twofold, and it will then drag on for a long time. Now, the government are trying to overcome this issue by recruiting 54 full-time judges, 108 part-time judges, but it's going to be an ongoing problem. And then really just to make things even worse, there's some figures on the screen as to what it might cost if you get the wrong side of a discrimination claim or even an unfair dismissal claim. £30,700 average amount for a disability discrimination claim, £15,000 for an unfair dismissal claim. It's an expensive business. Wage slips. Everybody issues wage slips to their employees, but as from the 6th of April 2019, it's going to be necessary to issue wage slips to workers as well. Now, workers are this sort of hybrid individual. They don't have a contract. They are under no obligation to work. They're often described as casual. They're not self-employed, but they're not employees. But as from the 6th of April, they've got to have a wage slip. It must show gross pay, net pay, variable deductions, tax and national insurance, any fixed deductions if you've lent this worker money. And if they're hourly paid, and many of them will be, you have to show the number of hours worked. And if they get a different rate of pay for a different type of work, then those two areas, or maybe three areas, maybe more, must be distinguished on the pay slip. So if you've got a guy who works in a warehouse and is also a driver, and he gets paid at different rates for being in the warehouse as opposed to driving, then both of those number of hours must be shown, and the rates of pay must be shown on the pay slip too. Now, this bit of news will probably not be of much assistance to people who are not currently running childcare voucher schemes, or who are running one and want to keep it open to new members, because as from the 4th of October, no new entrants can join a childcare voucher scheme. They've been very popular because up to £55 a week can be used to buy childcare vouchers out of untaxed income. So it reduces the employees' tax and national insurance payments. That's going to stop. It's probably too late for anyone to now join, but I wanted you to be aware so that if anybody comes and asks, can I join? The answer after the 4th of October has to be no. And something else that has just gone through Parliament, that has just been passed within the last week, is the Parental Bereavement Leave and Pay Act. What that says is that regulations are going to be brought into force. It will probably be about 2020. I hope it's an experience you never have to go through, but it is to say that employees are entitled to 2 weeks paid leave in the event of child bereavement or stillbirth after the 24th week of pregnancy. It appears that both mother and father would be entitled to pay. We will know the detail when the regulations are published, probably next year. Now, ACAS have been busy recently. They have published some guidance on employment references. I haven't put the website address on the screen, but if you just Google ACAS employment references, it will be there, and it will give some helpful guidance on how to provide a reference, what you have to put in it, what you shouldn't put in it. And it brings me on to an interesting case. Nigel Francis McGann applied for a job at West Atlantic. West Atlantic are an air freight company. They fly planes all over the world, and that they operate locally out of Coventry Airport. And they were recruiting pilots. And Nigel Francis McGann applied for a job. He was given the application form. He filled the application form in. It asked for the names of referees. So he gave one of his referees as Desilich Ture. Now, the employer accepted that. He got the job. He underwent training during his employment. But after a few months, West Atlantic were a bit suspicious about this particular referee. They were right to be, because it was Jabba the Hutt. Star Wars fans amongst us will know that Jabba the Hutt has another name, and Desilich Ture is one and the same. So the employer called him in, and grudgingly he admitted that yes, it was a false name. And so the employer gave him the opportunity of resigning, and he took it. But he said, well, I'm resigning, I want 3 months' notice. And the employer said, no, because if you hadn't resigned, we would have dismissed you. So he took them to the employment tribunal. The employer countered by saying, well, when you joined us, you signed a training fees agreement and promised to repay any money that we had spent training you. So we're claiming £5,000 back from you for the training you've had. And the employer was successful. Not only did the employee not get his 3 months' notice, he ended up having to pay his employer £5,000 for the training he'd received. I like to think it was a case of the employer strikes back. Sorry. And now here's a salutary, if not cautionary, lesson about dismissing for gross misconduct. Sometimes you think it is so obvious what I can do here. Well, is it? Mr. Grosset was the head of English at the Joseph Rowntree School in York, and he suffered from cystic fibrosis. He, in the course of his English lessons to his pupils, showed a film to a class of 15-year-olds, some of whom were vulnerable to self-harm. Okay, that sounds fine, until you learned that the film he showed was Halloween. It's 18 rated. He was showing this film to 15-year-olds. When the headmaster took over some classes on behalf of Mr. Grosset, he was dismayed. He started an investigation. He asked the governors to deal with it, and a committee of governors held a disciplinary, and Mr. Grosset was dismissed. They considered Mr. Grosset's disability, his cystic fibrosis, and felt there was no connection whatsoever between the disability and this action of showing the film. Well, Mr. Grosset wasn't happy. He took them to an employment tribunal, and at the last minute, at the tribunal, he produced medical evidence to show that he was suffering from stress as a result of his cystic fibrosis. He was considering having a lung transplant. He was highly stressed about it, and he said that was the explanation for him showing this unsuitable film. He won. He was successful. Now, I find it an extraordinary decision. At what point do you say that the conduct was so bad that no element of disability can overcome it? Well, clearly the tribunal felt this wasn't one of those occasions, and there are some lessons that we can learn from Mr. Grosset. First of all, the disciplinary sanction must be proportionate. The tribunal felt that the school had gone too far in dismissing him for this particular action. They said you must consider if there is a link, a causal link, between the individual's disability and the misconduct. And in this case, they found that the stress brought on by his cystic fibrosis explained why he had made that error of judgment. And thirdly, they said that reasonable adjustments should have been made. Those reasonable adjustments in this case, they said, was that they were working Mr. Grosset too hard. He was doing too much, and he should have been given less teaching hours.